recollection of the individuals who may have been the ones at that meeting who had concerns about the use of 75 Leverett Street, that he disclosed that information. So,
Your Honor, a year and 4 months later, the only thing that I can clearly testify to is that, A, I don't remember names specifically because I didn't write them down because they weren't anonymous, but B, to the best of my knowledge, not a one of them was or is an employee of the city of Keene in any capacity.
Okay, so you don't remember anyone?
Not specifically.
Do you recall generally how far from my home? Were they adjacent neighbors? Were they down the street neighbors?
I don't know specifically because I don't say, well, where do you live and how is that relative to the property? They were in that general stone throw neighborhood, if you will. A good arm could probably hit some of their windows a distance.
Okay, so in the discussion you've been having with the attorney here, you've been talking about lodging house, tourist home. The objection, most recent objection filed by Mr. Mullins stated that the property was in fact being used as a type of lodging house or tourist home. Would you agree with that assessment, Fred?
That seemed to be, that's my belief based on my findings and observations.
Now, let's see. So, which one was it? Was it a lodging house or a tourist home?
Your Honor, I'm going to object. I understand where Mr. Freeman wants to go with this, but we're starting to bleed over now into the other part of this process. I think the question that the court wanted us to focus on was whether or not at the time of the issuance of the administrative inspection warrant, there was sufficient probable cause for the issuance of the warrant. I did not ask Mr. Parcells any questions with respect to what he observed after he went into the property, because I understood that the court didn't want to get into that until it made a determination as a matter of law whether there was probable cause to issue the warrant in the first instance.
well, I think the question was, based on what Mr. Parcells learned from the various sources, whether it be neighbors or these internet postings that he found, whether that constituted, in his mind, a lodging house or a tourist home.
That's fine, Your Honor, just because I heard whether or not it was in fact being used in that capacity, and that came with something.
Good point. I don't want to go too far afield if we're still
So, is that the question, basically?
You know what, I'll withdraw that for now, and we can go back to that. So stand by, I've got a bunch of questions. And I can make sure I'm not missing anything here. At what point, Fred, excuse me, Mr. Parcells, at what point were the photos and web posts that you relied upon to get your probable cause, were those taken, were those posted online? You can review your notes.
I don't know when they were posted per se. I'm not real computer literate, as you and I have conversed about. They were there on whatever day in question I went and looked, and they were there. But when they were posted, I couldn't testify to that, honestly.
If you don't mind referring to page 17 in the book here, you'll see the Shire Society Forum post. You see post by Pete Eyre on, and then a date there towards the top, just for your reference.
Yes, I'm sorry. I read that into the record. January 4, 2012 at 12:44 and 27 seconds p.m.
Do you have any evidence that the people that Pete Eyre in the case, who made that post was still living at the home at the time of the raid?
I have no evidence to that effect.
Were you aware that Mr. Eyre and the other tenants who were in the home at that time, or the other tenant rather, in question decided to move out at the end of the very same month where we exchanged the emails? That would be the month of May.
No, sir, I was not aware of that.
Now, you recall talking about the emails that we exchanged in Q&A earlier, when I had asked you in my response to provide me with the evidence, because you had alleged, if you recall, that a lodging house operation was going on the property, I wrote back saying, I don't know what this is all about, but essentially I would like to know more. So I requested from you to provide me with the evidence and the city code that you were bringing up, and whatever evidence you were basing your probable cause on, so I could then present that to the tenants, and because they were still living in the house in early May at that time. But did you ever provide me with what I requested?
No, sir.
Why not?
I don't recall specifically that I can accurately testify to you, but clearly I did not. I don't know exactly why I did not at that time.
Do you feel like it was bad faith on your part to continue on with this administrative inspection warrant when I was obviously willing to work with you on possibly communicating whatever your concerns were to my tenants?
No, sir.
Well, if you have a communication from the landlord, me in this case, inviting you to continue to communicate about this so the tenants could be informed of whatever this issue is and maybe something could be worked out, don't you think it was an inappropriate move to proceed with getting this inspection warrant?
I do not.
Do you think that's because that this whole thing was actually about creating a pretext to enter my property?
No, sir.
Were you aware that at the same time, approximately the same time, a FBI investigation was proceeding regarding the property at 75 Everett Street?
No, sir, it was not.
Why were the Keene police involved in the raid?
They were not involved per se. They never stepped foot on your property. They were just in the neighborhood for the protection of anyone who may have needed to see.
Do you think it's just a coincidence that at the same time that the FBI was attempting to gain access to the property by attempting to set up people in an unrelated case about a drug buy, that you were also doing the same thing?
Objection to all the issues with respect to drugs and whatever. Mr. Parcells already testified he had no knowledge of the FBI's involvement in the property.
I'll sustain the objection.
So if it wasn't about targeting me as an activist, trying to get into the home, then why not honor my request so I could properly assess the situation? My request for further information.
Testified that I don't recall why I did not provide you with the, I am aware that you know full well how to access the city's website and to pull up that information, but I did not provide it to you specifically.
Do you feel like had you continued on with the emails that, with the information that I had requested, given that I had indicated to you that I was willing to talk to the tenants, that the issue, if there was an issue, may have been resolved without the necessity of you coming into my home?
Do I believe that would have been the case? No, sir.
Why?
It's my opinion that you have no desire to comply with any government.
Any more questions at this time?
Mr. Mullins?
Yes, briefly, Your Honor, on that issue. Mr. Parcells, with respect to your recollection, I know you direct your attention back to page number 1 of the document set.
Yes, sir.
You testified to this document already, isn't that right?
Yes, I did.
Mr. Freeman had at that point refused to allow you access.
Yes, sir.
He does make the request for information, is that correct?
Yes, sir.
All right, and that email is issued when?
May 3rd, 2012, 11:12 a.m.
Turning your attention to page 3 of the document, sir.
Yes, sir.
You testified to this document as well.
I did.
This was a no trespass order submitted by Mr. Freeman.
Yes, sir.
Did you understand this to require no further contact with Mr. Freeman?
It's a little broader than I believed it to be. I thought it was a more physical presence as opposed to a verbal or written communication, but in essence, he didn't want to hear from us.
No further.
Okay, so with regard to this no trespass notice, yeah, this, the first paragraph here, did you want to read that first paragraph?
As the owner of 73-75 Leverett Street, I do not want any agents, employees, and others associated with the city of Keene, herein referred to as the city, on my property.
All right, so it seems pretty clear that that only has to do with the property and not any other method of contact. Does it say anything in that notice about you can't email me or call me or anything like that?
It doesn't state that specifically. It does refer to persistent harassment. One might take writings as a form of harassment.
No, I don't think, I think harassment has specific definition.
Objection. no.
Okay, well, we're not having a conversation here. Freeman, if you have any other questions for Mr. Parcells, go ahead, otherwise.
Right, in fact, within this trespass notice, is there not actually a specification that I would like to be contacted if there is some sort of business that needs to be conducted?
Yes, sir.
So it left the means of communication open there, would you say?
I guess you could infer that.
What's that?
Yes, Your Honor, although clearly, depending upon where the court goes with this, we may need to have Mr. Parcells come to discuss what he saw at the property after the warrant. And also would reserve the right to call Mr. Parcells at the end of our case in chief in the event that there's any rebuttal necessary.
All right, Mr. Parcells, the one needs that. All right.
Your Honor.
Again, keep in mind, we're talking about just the
Yes, Your Honor.
issuance of the warrant.
Yes, Your Honor. Thank you. Call Chief, or Captain Gary Lafreniere to the stand.